Hi, good evening. Welcome to Criminalist Behavior Podcast, the podcast that takes you deep into the heart of Louisiana's history and current most chilling true crime stories. I'll be guiding you through the darkness of these crimes and all those involved. Each week, we dig deep on those forgotten crimes or those crimes that are currently happening with the underlying legends that continue to haunt us. So lean in, listen, and get ready because true crime is anything but ordinary. Stay with me as we unravel what happened in these mysteries and these crimes. So the pain of victims never truly fades. It echoes through generations. So today we're going to be on episode number 28. So if you're new, hi. You're listening to Criminalist Behavior Podcast. And this is your host, Sarah Soudier. And I want to thank you for listening to the show, and I really hope you enjoy it. So, trigger warning, first and foremost, the episode may contain content of a graphic nature, including descriptions of physical and sexual violence against adults, children, and animals. Listener discretion is advised. So, before I jump into the case, I want to share some great, exciting news and some things that have been happening. So, I'm not sure if I mentioned it last episode or not, but Criminalist Behavior Podcast and myself, Sarah Soudier, we have been nominated to receive a Women's in Podcasting Award. And with that being said, if you don't know much about that program, I will link everything in the show notes. And you could go on our social media, Facebook, Twitter, YouTube, Tumblr, TikTok, and I'm sure I'm forgetting something because, there's just a lot out there. But the Women in Podcasting Award is more than just an awards event. It is a platform for those who are considered a nominee and the actual winner to participate in opportunities for receiving recognition, increasing visibility of the pod, building community, and connecting with a broader audience. So I know I'm reaching some people, and I know I am just getting started. I think, like I said, I'm on, episode 27, 28? Yeah, 28. So, but I just want y'all to know we are nominated for an award, and it is under the documentary category, and it would be a huge help to me in the show if you would vote for us. Again, I'll link it into the show notes. And if you don't know what the show notes are, it's basically a description of what the episode's about. You could click on it and there's links, and I usually link my sources on where I get all my information. So I give credit where it's due. But the person with the most votes will win that particular category. And there are several categories. But true crime falls into the documentary category. And so there's literally 3 podcasts in the documentary Women's Awards. So I think we got a fair chance. I really hope we do. I'm just excited that I'm actually nominated. It is an honor. Just getting started. I think I started either in January or February of this year. I would literally have to go back, but there's more to come. I'm excited. I can't wait. But there's no fee for voting. So just click the link. Even if you don't want to vote for Criminalist Behavior Podcast, go cast your vote for Women's in Podcasting, and just whoever is your favorite podcaster, show them some love. But I really appreciate it if you voted for me. Again, my name is Sarah Soudier. All right. So that is that. So that was just some exciting news. So, another thing is, I'm finally reaching out to more people, and, some of the people from my work didn't even know that I was on a podcast, even though I really thought I was known, because my lab scientist was listening to me, our, prepaid biller, not prepaid, what is it called? Pre-billing. Wow. Pre-billing person listening, like, I did mention it several times, but anyways, they're excited for me. I love the love. I love my work. It is a great environment. Oh my God. Adrian is the best boss ever. And Kelly and Molly, oh my God. It's just amazing. So, and in case you're wondering where I work at a laboratory. So, yeah. Anyways, enough about that. If y'all have any questions, y'all could obviously reach out to me. We do have a website. Again, that's going to be linked in the show notes. Or you can email me at criminalbehaviorpodcast@gmail.com. So that is that. Super excited. Oh, y'all, guess what? So like, I do know that I mentioned, I don't even know what episode, but like, we were going through some personal matters because my life is hectic. Hello. My name is Sarah. And in case you didn't know, or you've been living underneath a pillow, baby daddy was arrested for first-degree murder, and that case is still gone, but my God, the stuff I will have to give to y'all once I am able to. I'm just pretty much waiting for the sentencing phase of this. I do know the grand jury did do their decision on behalf of this. I do have some inside scoop on what baby daddy was trying to do in mess of this, how it's been affecting our lives, basically my kids for that matter, and my kids' siblings. It is just a lot to process, but I will reach out and I will get that to you all. Now we're just gonna get started with today. And again, we're on the case of the murder of Mary James Peters. So this happened in the 1978. The date of the actual murder was April 4th, 1978. And it was literally characterized as a robbery at first, but then it turned into something more gruesome. So I'm going to give you a little info on Miss Mary James. First off, y'all, as with these old cases, there's really not that much info out there, unless you're like, I don't know, like, maybe it's because I'm just starting out, but like, I mean, I deep dive into everything. I don't stop, and sometimes it, like, prolongs me from getting cases out there. So, yeah, I try my hardest to gather as much information as I can about the victim, because I rather speak more about the victim than the killer, but sometimes that's not always plausible. But what I can tell you is what I did find was from the 1940s United States Census. Now, according to the 1940 census, again, take it with a grain of salt because I'm just trying here, but Mary James, we do know that she was born in 1893. In 1940, apparently she was about 47 years old and lived in Kansas City, Kansas with her husband Arthur James and daughter. The census stated that she had a daughter at age 19 at that time, and her name was Dorothy Mae James. In other sources, I found that Mary had two daughters. One was named Teresa and another named Mary, and she has several grandchildren and great-grandchildren for that matter. But due to it being, like I said, sort of old-timey with the date of birth and the information published, it's really hard to determine Mary James Peters' history and family and how she would end up in Wichita Parish in Louisiana. I did see on another census in the 1940s where there was a Mary James Peters that came, and she was like 2 years old and whatnot, but I don't think that is her, considering Peters is Mary's married name. So it would be under Mary James. And this is literally what I found, what I just told you. So at the time of this incident, Mary James Peter was legally blind, but she was able to function on her own. She was a small woman. She stood about 5'1", and she weighed about 110 pounds. Yeah, I would kill to weigh that again. But anyways, not literally. Don't take that. But she lived at home alone, and like I said, she was 85 years old. Y'all, if y'all hear this little bell happening, apparently my cat decides it wants to just be by the door banging it. So bear with, and please, I'm going to try to edit that out, but if I can't, just know my cat is going crazy. So Mary kept her doors bolted and did not allow strangers to enter at any circumstance. There was a total of 3 locks on the main entrance door. And according to Mary's daughter, Teresa, which we know for a fact is Mary's actual daughter, Mary was very fond of her neighbor, Rita Baldwin, but was afraid of Rita's husband, and her husband's name was Tim. According to William Odell Jones, Marilyn was also afraid of Tim. Now, I will go into depth on who all these people are and how they come to play, but this is just a little background story. And Mary attended church every Sunday with her friend Ledvic Herlevic. I really hope I said that correctly. But a woman who Mary knew since Ledvic was born. So, like, they attended church together every single Sunday. So, how does Timothy and Rita and all them fit into this case? So, Timothy Baldwin, he was married with Rita, and they had 7 children together. They were neighbors of Miss Mary James Peters in West Monroe, Louisiana, and that was between the years of 1971 until 1977. Timothy was a former Cub Scout leader, and Mary was the godmother to their youngest son, Russell. So Miss Mary was a longstanding friend of the Baldwin family. Like I said, she was just terrified of Tim for whatever reasoning. And Tim met her in 1973 after they developed a close relationship because Rita became really good friends with Miss Mary. So that's whenever Rita introduced Mary to her husband, Tim. And like I said, she was the godmother of one of their twin boys, Russell. And she would be remembered by always bringing the boys' birthday gifts. And literally one of the gifts was of a savings bond. And Tim frequently did the handiwork around Miss Peters' house just to help her out. So it seemed like they had a good, friendly neighbor relationship. So where did it turn, right? What made Miss Mary afraid of Tim? During the latest part of their stay in West Monroe, that is, Tim and Rita, a man named William Odell Jones also lived with the Baldwins. And this happened because they lost their job and they didn't have no place to go, so they took them in. So the group went to Bossier City for 6 months and then moved to Ohio. The oldest daughter, Michelle, remained in West Monroe with one of her brothers. A second son entered the service, so he went along his way. And Marilyn Hampton and her 3 daughters stayed with the Baldwins, aka Tim and Rita, in Ohio. Marilyn, Tim, and her children then left, and they were accompanied by William Odell Jones. Tim and William worked together in a business of installing aluminum siding, and after the departure of her husband, Rita got in financial difficulties and was picked up on bad check charges. So her 4 younger children then went live with Michelle, which would be their older sister, in West Monroe. Tim, William, and Marilyn and her 3 children then went about their own little lives. The group traveled to Florida, and this is where they decided to lease a 1978 black Ford van in Tampa, Florida. And this would be their last means of transportation in 1978. So on August 4th, 1978, Marilyn Hampton and Timothy Baldwin drove the van to West Monroe. William Odell Jones and the children stayed at a cabin in Home State Park near Jackson, Mississippi. Tim and Marilyn visited Michelle, which would be Tim's daughter. They visited her apartment in West Monroe, but they left around 8 o'clock that night. The park manager, Mike Verado, knew Tim and the fact that he drove away with an adult woman, but he couldn't identify if that was Marilyn Hampton or not. He just seen Tim leaving the park with an older woman. The park manager, Bernardo, did see that the 3 children and William Odell Jones stayed and remained at the park that day. William knew that Marilyn and Tim intended to rob Mary James Peters, which was a former neighbor of the Baldwins, and use her money to settle down. Shortly after, a van was seen parked in front of Miss Mary James Peters' house. It was said to arrive somewhere in the hour of 8 p.m. It stayed parked in front of Miss Peters' house for about 2 hours. And during that 2-hour duration, neighbors Paul Rice and Robert Grissom observed that someone or something was being beaten by a white male subject. Paul and Robert did not get involved, and they noticed that a man and a woman were leaving that residence between 10 and 11 o'clock that night, so approximately 2 to 3 hours later. Shortly before the man and the woman left, people passing by saw and heard indications that someone in the Peters home was being beaten. Witnesses who saw 2 people leaving the Peters house on the night of the murder, April 4th, 1978. Yeah. Spoiler alert, murder, not robbery, murder. Described a man and a woman, both white, both in their 20s, the man with long hair and wearing short sleeves. Mr. Baldwin, who is white, was 38 years of age, had a crew cut, and always wore long sleeves because he got a lot of tattoos in his younger days, and he used to conceal them by wearing long sleeves. So he would normally not be caught wearing a short sleeve shirt. So again, Paul Rice could not state that Marilyn Hampton was the actual woman that he seen leaving for sure, but he did state that her appearance is of a strong similarity. Paul and Robert stated that the woman who was seen leaving the area that night seemed to be carrying something in her arms. Neighbors trying to identify the man they saw leaving the house pointed out someone other than Tim Baldwin in a police lineup. So Tim was not actually selected in a lineup by those neighbors that seen him, Paul and Robert. The witnesses stated that they saw a brown gold Dodge van parked that night outside the Peters house. But if you recall, Tim and Marilyn were driving a black Ford van, not a brown Dodge van. So Mary James Peters, who actually regained consciousness before her death, stated that she did not know her assailant, although she really knew who Tim Baldwin was. So, not sure if she was just afraid to say that it was Tim Baldwin or if it was actually someone else that actually beat her. The Baldwin's fingerprints were found in her house. However, he admitted that he had visited her in West Monroe that day. So, in case you missed the beginning of this story, Tim used to always go help out, be a little handyman at Mary James Peters' house, so his fingerprints would be there. And like I said, she was 85 years old, and she was a blind woman, so she really couldn't see much of anything, obviously, because she's blind, but so Tim helped her out, so it wouldn't be strange for his fingerprints to be inside of her home. And the fact that he admitted to going to Mary James Peters' house that very day, I mean, it could have just been a stop and say hi, but I digress because we're going to get further in. So, Tim testified on his own behalf and admitted that he and Marilyn visited Mrs. Peters that evening, but they denied murdering her. Mrs. Peters, who was 85 years old, she was beaten with various things. Among those things was a skillet, a stool, a television, and a telephone. Common household items, y'all. A skillet, a stool, a television, like 85 years old. She's blind. You really think you needed to use all of that? Hell, a skillet, I'm sure, an iron skillet would have done enough damage alone. Like, why you had to include the stool, the TV, and a telephone, bruh? Like, I really think that's a little overkill, seriously. Anyways, she remained on the kitchen floor overnight, and she was actually discovered the next morning, right before noon, and she was discovered by Wichita Council Meals on Wheels employee named Elsie Moore Bryce. And Elsie was bringing Mary her meal for lunch. And it happened about 11:30 a.m. when Mary's body was actually discovered. Mary's body was black and bruised, and she was lying on the kitchen floor, moving her hands. So she was still alive, she was still breathing, but barely moving. She was just moving her hands. And although Mary was helpless and incoherent, she tried to defend herself against the police officers and the ambulance who took her to the hospital. Dr. A.B. Gregory saw her in the emergency room around 12:30 p.m. on April 5th, 1978. And he found her kind of semi-comatose. So she was pretty much just out of it. The doctor indicated that her left cheekbone and jawbone were shattered. She had brain damage from multiple contusions and lacerations. And according to Dr. Gregory, Miss Peters could not communicate rationally. She died the following day on April 6, 1978, of all the injuries she sustained. Dr. Frank Chen, who performed the autopsy, attributed her death to massive cerebral hemorrhage and swelling, secondary to external head injuries. So, she died from brain, like her brain and skull being beaten, y'all. A broken iron skillet, a telephone, a television set, and other items have been used to inflict the wounds on Mrs. Mary James Peters. Mary could not communicate well, but she tried to defend herself amongst those trying to render her care. And I'm sure she was trying to do the same with her attacker. There were no signs of forcible entry into the home. So now we're going to jump into when Marilyn and Tim arrived back at the park. So Marilyn and Tim returned to the Holmes Park around noon on April 5th, 1978. Marilyn told William Odell Jones that, and I'm going to quote this, "The lady, Mrs. Peters, yeah, she was still kicking," close quotations. And she stated when they left her that pretty much Miss Peters was still alive, so she was just severely beaten. Tim and Marilyn were located in El Dorado, Arkansas. Tim Baldwin signed consents for search of their motel room and the van. 2 blue bank bags, one empty and one containing savings bonds and certificates of deposit payable to Mary James, were found in the van. William Odell Jones, who Marilyn Hampton and Tim had made inculpatory statements to, both before and after the crime, helped police officers locate the safe which belonged to the victim, and they located that in Lafourche Canal in West Monroe. Timothy Baldwin's finger and palm prints were found on various items in Mary's home: a cigarette lighter, a television set, and a cup of coffee, to be exact. And Mrs. Mary did not smoke, but a pack of Pall Mall cigarettes was found at the scene of the crime, and that is the very same brand that Marilyn Hampton smoked, just a FYI. So Marilyn Lee Hampton and Timothy George Baldwin were arrested on behalf of this after William Odell led the police all this evidence. They were booked. They were indicted by a grand jury for the first-degree murder of Mrs. Mary James Peters. The trials were held, and the jury, I'm going to probably butcher this word, only because I'm trying not to butcher this word. They made a unanimous, oh my God. Okay. So they voted that she should be sentenced to life in prison and without the benefit of parole, probation, and suspension of sentence. Y'all, I could say this word any other time, only because I'm trying to focus on not saying it incorrectly. Well, I say it incorrectly. So, anyways, that word. Y'all know what I was trying to say. So, Marilyn appealed her verdict. And she stressed this appeal based on 6 assignments of error. And Tim did the same, but he had like 50 different assignments of error. So I'm going to go over the 6 assignments of error that Marilyn Lee Hampton tried to appeal on her first-degree murder charge. Number 1, there was insufficient evidence at the preliminary hearing to establish probable cause to charge with first-degree murder or a lesser included offense. Number 2, the court should have granted a change of venue, stating it would be inadequate due to publicity around the murder, but this proved to be true as there were no public news stories involving this case. So that assignment error that she was suggesting lacked merit. And number 3, they allowed hearsay testimony by the state witness, Paul Rice. Rice testified that he saw a man and his companion woman leaving the Peters residence. And this is due to the statement that Paul Rice stated, and I'm going to go ahead and read that statement. So, Paul Rice stated that whenever the woman and man was leaving Mary's house, that the woman stated, open quotations, "We'll see you later, Mrs. Peters," close quotations. So that assignment of error was stated to be part of, to be part of the rest, since it occurred as Marilyn was leaving the scene of the murder, and it is showing an attempt on her part to prove that Mrs. Peters was still alive, and that statement was not allowed into evidence. But they stated that number 3 assignment of error lacked merit, so it wasn't justified. So assignment error number 4 that Marilyn listed was they allowed hearsay testimony from William Dale Jones on statements that were allegedly made by Marilyn. William stated that Marilyn was in the van when Tim discussed a robbery and possible murder of Mary James Peters. But there was no testimony about statements made by Marilyn before the crime, proving her presence of the conversations, and she was aware of the nature of the trip with specific intent to commit that murder. So she was trying to basically say it was not a first-degree murder. She didn't plan it. They were planning to rob her, so this is her trying to explain that. The statements made that she was still kicking, that supposedly, allegedly, Marilyn spoke to William, led to free admission to her role on the crime as evidence. That assignment of error also lacked merit, so it had no cause. Number 5, Marilyn's reason, was the court allowed evidence, Exhibit S-16B, which was a small colored photo of the victim Mary James Peters, which established her identity and the cause of death. The assignment also lacked merit. So, number 6, and the final assignment of error that Mary was trying to appeal on, was the jury verdict was contrary to the law and evidence, and that the trial court erred in denying a timely motion of a new trial. The only testimony to connect Mary with the crime was from William Odell Jones. The court stated there was other ample evidence to establish beyond a reasonable doubt that she was a participant in the robbery and the murder, and therefore they ruled that that assignment of error lacked merit as well. So for those reasons, the conviction and sentences were affirmed, meaning you have no evidence, you have no substantial reasons to appeal this court's decision. They all lacked merit. The decision still stands. So, like I said, Timothy did the same thing, but he had, like I said, 50 different assignments of error. I am not about to sit here and list all 50, but I will mention a few just so you are aware of what's really happening. So, Timothy George Baldwin, he was actually sentenced to die for the murder of Mary James Peters. He was found guilty, and he was found guilty by an all-white jury, and they recommended the death sentence based on 2 findings. Before I read those 2 findings, it should be known that Timothy George Baldwin was an African American, and he was convicted by an all-white jury. So he had no member of his peers on the jury, so it really was not a fair hearing. However, these are the 2 findings on behalf of the jury on why they recommended the death sentence. Finding number 1. The offender was engaged in the perpetration or attempted perpetration of an armed robbery. It was noted that Tim actually had a knife on his person. And 2, the offense was committed in an especially heinous and atrocious or cruel manner. A panel of this court stated that his execution to consider his claims of ineffective assistance of counsel at guilt and sentencing phases of his trial. The performance of his attorneys in guilt phase was not constitutionally deficient. The alleged deficiencies in their investigation into considerations of mitigation of sentence have not been shown to have caused actual or substantial prejudice to the petitioner's defense. Baldwin's request for habeas corpus was denied. So, in case you didn't understand that law germ, pretty much Baldwin was stating that he was only convicted because he was a black man and it was an all-white jury, and he stated that his counsel at the time that was representing him did not help in his case at all. But the court ruled that their findings of sentencing him to death and life in prison was due to the fact of those 2 findings, that he had a knife on him with the attempt to do an armed robbery, and he was also the amount of damage that was actually done to the victim. So it wasn't because it was an all-white jury and he was a black man that he was charged. It was because of the evidence of that, which to each his own, but you are supposed to have a jury of your peers. So someone of African American, his race, should have been present on that jury. But again, this is 1978. You can't expect anything better than what they already have, which is very much disturbing, might I add. So, like I said, that habeas corpus request was denied. Tim stood trial for her death. The jury convicted him of murder in the first degree and recommended death on finding that the murder was actually committed in the heinous, atrocious, and cruel manner, and it happened during the perpetration of an armed robbery. And Timothy Baldwin was sentenced to die by electrocution. Tim has tried to exhaust his appeal countless times to the Louisiana Supreme Court, but he was rejected and denied. Baldwin then mounted his initial collateral attack on his conviction. There were 16 claims that were advanced. Among them was an allegation that his counsel was ineffective because they failed to move for a new trial after there was evidence that a hotel receipt corroborated that Tim had a damn good alibi. So that hotel receipt proved that Tim was not at Mary's house on the alleged time of her murder. That's what this receipt is supposed to show. But Tim's application for post-conviction relief was denied by the state trial court for want of jurisdiction. The Louisiana Supreme Court declined review of the state trial court's decision, and the proceedings in the federal court on his petition for habeas corpus yielded a type of consideration of merits on all those claims. They were all rejected. The Louisiana trial court then ordered Tim to be electrocuted on May 27, 1982. 10 days before his sentence was to be carried out, Tim initiated the present proceedings for post-conviction relief. His petition was again denied by the state trial court on the day it was filed, and by the Louisiana Supreme Court the following day. 1 day later, he presented identical claims to the federal district court. The district court denied his petition for habeas corpus relief without a hearing and declined to stay his execution. 3 days before the appointed date of execution, so May 24th, the court granted a stay pending an appeal. So, in case you don't know what that means, was 3 days before Tim was supposed to be electrocuted, the federal court granted him an appeal request. So that's to postpone that May 27, 1982 electrocution. Tim asked for a reconsideration of the earlier ruling that his trial counsel failed to move for a new trial based on an alibi of the motel receipt that did not produce ineffective counsel on his behalf. In that presentation of the claim, he argued that the motel receipt viewed in the context of the entire trial record. And he stated that it demonstrated that he was 70 miles away from the West Monroe home at the time Miss Peters was fatally beaten. He asked that a writ of habeas corpus issue immediately on the ground that the record as it is presently constituted discloses his innocence and therefore inadequate representation by a trial counsel. He asked for an evidentiary hearing exploring his former attorney's decision not to move for a new trial, and that is what he decided to take up on a later date. And whether or not an evidentiary hearing would be necessary to resolve a charge of inadequate representation, the petition's allegations could not be resolved without evidence beyond the record. So the hearing was actually required. So this meant that the claim may be resolved without a hearing. Baldwin's challenge is limited to the reasonableness of his trial counsel decision to forego a motion for a new trial in view of what he argued as inescapable conclusion of his innocence. So it would actually establish him an alibi of being 70 miles away if they actually allowed that hotel receipt to be entered into evidence. All of the information that was relevant to Baldwin's trial's attorney's assessment of the motel receipt and found the foundation for a motion for a new trial was now on the forefront. The record in support of the present petition included a complete transcript of the trial testimony and a copy of the motel receipt. Tim's present counsel has ably directed the attention to the portions of the record bearing directly on his behalf. And the debate was on various different things, and the trial record would neither aid nor enhance that type of evaluation. So they basically considered Tim's allegations of ineffective post-trial representation, and they actually pulled the Sixth Amendment, meaning the Sixth Amendment applicable to the states through the 14th Amendment. It entitles that a criminal defendant to counsel reasonably likely to render reasonable and effective assistance. The standard by which court evaluates claims of ineffective assistance of counsel is clearly defined. So the 6th and the 14th Amendment went hand in hand, basically stating that Tim should have had adequate counsel and good representation regardless of his attorney being appointed by the state. So constitutionally, effective assistance of counsel is not errorless counsel and not counsel judged ineffective by hindsight. Instead, it should be the determination of whether a counsel render reasonable effective assistance in each case totally on facts in the entire record. So they had to consider that the counsel's performance was on the best behalf of Tim Baldwin. And what strengthened the prosecution's case and the complexity of the defendant's possible defenses was they recognized that while attorneys are not held to a high standard in capital cases, the severity of the charge is part of the totality of circumstances in the entire record. So that should have been considered in the effective assistance of counsel. So they're not stating that it was because of a normal everyday crime, but this is my bad. This is an actual capital case. It's first-degree murder. So to establish a constitutional violation under that particular standard, the person, the petitioner, which would be Tim, must demonstrate that both identifiable instance of seriously inadequate performance by his appointed counsel and some actual disadvantage to the course of his defense that resulted from that lapse of having an adequate counsel. So basically, they went through everything and they evaluated Tim's claim of the ineffective representation of his court-appointed attorney and how they didn't move for a new trial based on the motel receipt, but the motion for a new trial was supposed to be based on that injustice had been done to the defendant. And unless that was shown to have been the case, the motion shall be denied, no matter what allegations it is grounded upon. So the court, on motion of the defendant, shall grant a new trial whenever, and these are the reasons: new and material evidence, notwithstanding the exercise of reasonable diligence by the defendant, was not discovered before or during the trial. So that would be cause for them to have to grant a new trial, is if that evidence was not available while the trial was happening, but it came up afterwards. And if the evidence had been introduced at that trial, it would probably have changed the verdict of judgment of guilty. So basically, if that evidence was available at the first trial, then they wouldn't be able to motion for a new trial. If the evidence became available after the trial and a conviction, then they should have right to have a new trial and present that type of evidence, but only if it would have actually persuade a different verdict. So basically they're saying that if this evidence was submitted during the first trial, would it be possible for the verdict to be not guilty as opposed to guilty in first degree, right? And so, according to Art 851, consistently has been interpreted to demand that the defendant must show not simply whether another jury might bring in a different verdict, but whether the new evidence ought to be produced that a different result from the verdict would be reached. Tim stated that the new evidence he would offer in light of trial and testimony to the movements of the day of the assault and to the time the actual murder happened for Miss James Peters would exculpate him. So it would basically prove that he was not there at that time. But on careful examination of all the records in the trial, they disagreed. And the information provided by the receipt was very limited. It indicated that Baldwin did check into White Sands Motel in El Dorado, Arkansas on April 4th, 1978, but didn't specify a time, which he could have checked in at any given time, before, after, but it was on that day. 70 miles is not a long time to travel, so he could have done this. So that evidence is null and void. But Tim's argument depended on a construction of the trial record, both to establish that the murderer left Mrs. Peters' home too late to arrive in El Dorado before midnight on April 4th. And to eliminate that possibility that Tim checked into the White Sands prior to arriving at Mrs. James Peters' residence, there was neither proposition supported by a fair reading of that record. So they couldn't prove that that receipt would make a different verdict. So it would prove that Tim would be not guilty. So, yeah. Receipt means nothing, Tim. So the trial testimony linked the murderer and Baldwin with a dark-colored van. Half a dozen witnesses stated that a van was parked in front of Mrs. James Peters' home for several hours on the night of the 4th. Two of those witnesses, Paul and Robert, testified that they first noticed the van when they walked past Mrs. Peters' house, and that was about 8 o'clock, right? And as they were passing, Rice heard scuffling happening, and he called Grissom back. And both men approached the house, looked into the lighted kitchen through an open window. And apparently, as they were watching through that window, a man was swinging his arm, bending the downward string of striking a target on the floor, circling and jumping as if to stay on target. The man struck repeatedly, and this is when Paul and Robert decided they were seeing a domestic violence incident happen between a husband and wife, or a boyfriend girlfriend, and they resumed to just go on about their business. They walked by to a nearby convenience store, and 8 to 15 minutes later, they returned. They both noticed a man and woman standing in Mrs. James Peters' yard near the van. The woman appeared to have something in her hand, and Rice testified that he heard the man called... Rice testified that he stated that the man stated, "We'll see you later, Mrs. Peters," then watched them get into the van, and they headed north. Grissom also testified that he saw them get into the van, but that he turned his back and did not see the van pull away or which direction that they went. So Rice and Grissom's testimony puts the assailant's departure about 10:25 p.m. to 10:30 p.m. that night. Their testimony was contradicted only as to the time that the vans departed by recollection of another neighbor, Mrs. J.C. Hawkins. Mrs. Hawkins stated that she noticed the van from the kitchen window of her home, which is cat a corner from Mrs. Peters' house, And she saw that the van was there at 11:10 p.m. So people's times are off. So that is what? That is without a reasonable doubt? No. That gives you reason of doubt if the neighbors cannot come up with an adequate amount of time on what time they seen that the van was there, what time the van left, all that good stuff. So, Tim admitted at the trial that he was driving a dark van on the night of April 4th and that he took his girlfriend with him, to visit Mrs. Peters that night. Now, why would Tim be going to visit Mrs. Peters whenever Mrs. Peters stated she was scared of Tim? But as we know before, they planned to just rob her, right? So, again, the van was seized by the police when Tim was picked up several days later with Marilyn in El Dorado. Subsequently, he agreed for the police to search the van, and they turned up with that bank bag containing savings bonds and certificates of deposit in Mrs. Mary James Peters' name. El Dorado, Arkansas is about 70 miles north of West Monroe, Louisiana. And Tim relied on Hawkins' recollection that she saw the van outside Mrs. Peters' home at about 11:10, argues that he could not leave West Monroe after 11 p.m. and arrive in El Dorado before midnight. He offered proof of evidence by that motel receipt of the truth and his claim that he left Mrs. Peters before the attack occurred. Tim does not argue that his arrival in El Dorado before midnight is inconsistent with Rice and Grimm's testimony of the assailant's departure from the van's presence, but it stated that they cannot say that Hawkins' testimony to the van's presence should necessarily be accepted over Rice and Grimm's testimony. So, basically, they stating, no, I saw one person, she might be senile, pretty much. We're just going to go with what Rice and Grimm stated. The hell with what Hawkins stated. Even though there were certain conclusions that can be drawn from the record as to where Tim's whereabouts were on April 4th prior to his visit to Mary James Peters' home. Tim testified that he and his girlfriend traveled together in a van, and they started out on their journey for about lunchtime from the park and located 50 miles north of Jackson, Mississippi, but they arrived in West Monroe about 2 o'clock in the afternoon. And the park superintendent testified that he noticed around 10 o'clock that morning that Baldwin and the woman in the van were gone. Michelle Baldwin, which is the stepdaughter of Tim, and the park hold up, I lost my place. I do apologize. Michelle testified that she met her stepdad in West Monroe about noon on the 4th of April. And the record clearly discloses that Tim, after once arriving at West Monroe, did not leave the town until after he stopped at Mary James Peters' home. But there was an indeterminate amount of day that went by before Tim got to West Monroe. So what was he doing in between those hours, right? The record does not address much or anything substantiated enough that Tim did not stop in El Dorado on his way to West Monroe. So, finally, Baldwin's conviction was supported by more than his circumstantial evidence. Michelle Baldwin testified that on the afternoon of the 4th, before his visit to Mrs. Peters, her father told her he was facing Old Smoky. Now, why would Tim tell his stepdaughter Michelle that he is facing Old Smoky? In case you did not know, the term Old Smoky was referred to the electric chair. So, why would he state that he is facing the electric chair, right? So, Michelle testified that when she said that she didn't understand, Tim told her that he meant the electric chair. Michelle spoke again with Baldwin Michelle spoke again with Baldwin on April 7th. By then, she was aware that Mrs. Mary James Peters was severely beaten and died. And she believed that it was intended assault on Mrs. Mary James Peters and that her father had referred in his mention of Old Smoky. She asked, why did he do it? She stated that Tim answered only. She didn't suffer. It was fast. That was a direct line from Tim Baldwin that he told his daughter, Michelle. She didn't suffer. It was fast. William Odell Jones, which was a friend and traveling companion of Tim and Marilyn and her children, he testified that before going to West Monroe, Tim told him that Mrs. Peters had money and that if he had to kill her to get it, he would. William also testified that on that day of the assault, Tim admitted to him that he had killed Mrs. Peters by striking her with his hand, a telephone, a frying pan, a television, a mixer, and he stole her valuables. On the record before us, they could not conclude that the motel receipt, if presented on a motion for a new trial, would have proved that Tim was not guilty. It is not consistent with the conclusions that he was at Mrs. Peters' home at the time of the assault, but at the same time, if he was actual assailant. It is not such evidence that, as required by standard controlling of the granting of a new trial in Louisiana courts, ought to have produced a different result. So they basically stated the receipt would not produce a different result. So they stated that Tim Baldwin was not prejudiced by his trial attorney's decision to not pursue a motion for a new trial on the strength of the receipt. So that's whenever that habeas corpus relief was actually denied. So Tim's second argument in support of his habeas corpus petition charges his trial counsel with incompetency in their preparation for the sentencing phase of his trial. He claims that they failed to conduct a substantial and independent investigation into one-line defense on which they staked their attempt to stave off the death penalty. He supported his claim with affidavits attesting his counsel's inattention to matters in the mitigation of punishment and to the substance of the evidence in which claims would have been found available if they had actually looked. He asked for a new sentencing hearing, or at the very least, an evidentiary hearing on his allegations of inadequacy. So, basically, he stated that they failed to conduct a great investigation. They didn't have enough evidence to prove that he was actually the person to commit the crime. It was all circumstantial, and pretty much he has reasonable to be released. That's his argument. But the matter in that did not end with an evaluation of adequacy of trial counsel's investigative efforts and the validity of the strategic choices, but it actually said that not every breach of duty to investigate lays the basis for issuance of a writ of habeas corpus. A petitioner, aka Tim, who was seeking the resentencing through allegations of a discrete failure by his trial's investigation in preparation for his sentencing hearing, may not rest on proof only of the failure alleged in his constitutional dimension. So, he was denied, y'all. He was denied. His argument did not analyze ambiguities in the question of the adequacy of his trial attorney's preparation for his sentencing hearing, and the claims that he had that supposedly would clear his case simply did nothing to prepare the penalty proceeding. And basically, he had a far weaker case, so again, denied. So Tim's attorneys put on a case for mitigation of punishment based on their client's good character in the years preceding this offense. Basically, they had 3 witnesses that was close to Tim, and they offered pleas of mercy for him. Tim's wife and his stepdaughters, Michelle and Doris, described that Tim's years of hard work and dedication before this event was all for his family. And both Michelle and Doris emphasized the love he has shown equally to his biological children as well as his stepchildren. And that he had a sense of moral responsibility that he instilled within them whenever he was raising them. And Tim's wife spoke of his deepening sense of failure and futility in the face of worsening financial problems. And she stated that Tim was a heavy drinker due to turning to alcohol after an abstinence. So she recalled his 3 children who were still in need of a father, but he was absent in their lives, and he just started drinking real heavily. So basically, every attempt that Tim went to prove to be released from prison, he was denied. He was denied. He was denied. Tim apparently offered affidavits of 11 people who would say that he was of good character, kind nature, and a hard worker, but none had known him for a prolonged period of time, and none had been in contact with him during the last 2 years prior to this happening. Some only knew him in talking or passing by, but didn't really know him. Others had been neighbors or co-workers, and that was like back in the beginning 1970s. And one was a cousin close to Baldwin. While they were children, another was a parish priest who serviced Tim and his wife. And their testimony would have served only to corroborate the portrait of a man sketched by his wife and daughters. So basically, everybody that Tim was trying to get to speak on his behalf was pretty much all friends and family to him. So how did his daughters and his wife see him? It's pretty much all Tim had to offer. So you're not really standing on nothing, because of course your wife and children is going to take up for you no matter if you're right or wrong, even though you're wrong, allegedly. So nonetheless, they could not conclude that the evidence was of a high significance, that if it was omitted, that his claim would be approved. So basically, everything was just, again, denied. Careful examination of Tim's charges of ineffective assistance led the courts to the conclusion that the courses in which he claimed his trial attorney should have taken would not have been of substantial benefit in his defense. The judgment of the district court denied his petition for habeas corpus and affirmed their decision. So basically, the sentencing to death was still in play. Tim presented a third claim in his petition for habeas corpus, and he argued that the Louisiana Supreme Court's practice of conducting its proportionally reviews of sentences out in capital murder cases on a district-by-district basis failed to satisfy the 8th and the 4th Amendments to the U.S. Constitution. But first-degree murder is killing of a human being when, 1, the offender has specific intent to kill or to inflict great bodily harm and is engaged in the perpetration or intent to kill or to inflict great bodily harm, or aggravated kidnapping, aggravated escape, aggravated arson, aggravated rape, aggravated burglary, armed robbery, or simple robbery. So, if you recall, Tim went over there with a knife on the attempt to do an armed robbery on Mrs. Mary James Peters. And based on the law, whoever commits the crime of first-degree murder shall be punished by death or life in prison at hard labor without the benefit of parole, probation, or suspension of sentence in accordance with a recommendation of the jury. So Louisiana allows a sentence of death to be imposed if The jury finds beyond a reasonable doubt that at least one statutory aggravating circumstance exists, and after consideration of any mitigating circumstances, recommends that the sentence of death be imposed. The recommendation must be unanimous. So basically, they're stating that only one of those reasons the jury should find beyond a reasonable doubt that one of those charges of aggravating circumstances exists, the death penalty would be imposed. And following considering aggravating circumstances, the offender was engaged in perpetration or attempted perpetration of aggravated rape, kidnapping, burglary, arson, escape, armed robbery, or simple robbery. So in this instance, it would be armed robbery. And the offense was committed in an especially heinous, atrocious, or cruel manner. Mitigating circumstances include the offender has no significant prior history or criminal history. The offense was committed while the offender was under the influence of extreme mental or emotional disturbance. At the time of the offense, the capacity of the offender to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was impaired as a result of a mental disease or defective intoxication. So they're pretty much saying that he only did it because he had a mental problem. Was he bipolar? Was he schizo? No. If you recall, they stated that he turned into alcohol, so he apparently was impaired. He might have been drunk, but drunk or not, you still kill somebody regardless. So, the petition included the allegation that the Louisiana Supreme Court conducted its review of the death sentence against Tim and it being actually permissible. Tim has exhausted state remedies on 3 claims presented on the federal district court: that his trial counsel was ineffective, and that they failed to move for a new trial based on the motel receipt, that his trial counsel inadequately prepared for presentation of and presented evidence in mitigation of punishment at the time of sentencing hearing, and, of course, on the Louisiana Supreme Court's proportionality review procedures being unconstitutional. So, let's see. Another argument that Baldwin made was he complained that his trial attorneys failed to prepare his wife and his stepdaughters for their testimony on behalf of the sentencing hearing, and that the attorney's closing argument was lacking, and that he failed to mention that Tim had no prior record of being a violent criminal. But he does not specify how Tim's family's testimony might have been approved, nor does he deny that emphasis on the absence of violence in his criminal record would have served as well enough to prove of any prior criminal activities. So, as to alleged deficiencies in the closing argument, they declined to embark on a course of regulation, a retort condemned not for improperly, but for the absence of intensity. So, Tim was stating that he should have prepared the wife and daughters before they were testifying against him for the sentencing hearing, which, why would you prepare them? Like, would you want to give them adequate time to be able to make up a story, to have the same story, to collaborate with what Tim is saying? No, they did that because they wanted to make sure that they had no time to collaborate a story and lie on the stand. So Tim's appeals were rejected, and his lawyer, William Quigley, said there was nothing more he could do on behalf of his client. Baldwin's daughter, Michelle, testified during the trial that her father told her he was facing Old Smoky, a.k.a. the electric chair, in the afternoon before Mrs. Peters was killed. She asked him to explain, and that's whenever he told her he meant the electric chair. She also stated to him 3 days later, after the slaying of whether he killed Mrs. Mary James Peters or not, he replied, "She didn't suffer, it was fast." So, They stated that the prison warden, Frank Blackburn, stated that Tim Baldwin is calm and collected. And hours before he was electrocuted, he pretty well feels there's nothing left in the way of appeals. About 50 people marched outside the governor's mansion early that Sunday evening to protest Mr. Baldwin's execution. The fourth in Louisiana in the past 9 months. The Supreme Court voted 7-2 that afternoon to let the execution proceed. Justices William J. Brennan Jr. and Thurgood Marshall dissent from the ruling, but there was no further comment from the court. Mr. Timothy Baldwin was pronounced dead 12:13 a.m., according to Department of Corrections officials in Baton Rouge. Before the execution, Mr. Baldwin, 46-year-old, ate for his last meal. He ate bacon and tomato sandwiches as he requested, and he telephoned relatives. Yeah. Do people still eat that? Bacon and tomato sandwiches? Of all things you could request for your last meal. Bacon and tomato sandwich? That doesn't even sound good, bro. I'm going to go all out. I mean, go big or go home. I mean, you're dying anyway, right? So, bacon and tomato sandwich. Okay. So, before Tim was strapped to the electric chair, he looked at the Louisiana Pardon Board chairman, Howard Marcellus, and he stated this: "Y'all are about to execute an innocent man, and someday you'll have to answer for this." So, this case shows that even Louisiana's two-tiered proceedings for imposing such a penalty, a system for Supreme Court has upheld, cannot necessarily prevent the injustice. The excess or arbitrary or capricious judgments it was supposed to do away with, and nothing in the criminal justice system can, especially when the public is fear of crime and demands that something be done about it. That makes it all more important that death is different from any other penalty society can impose. Tim Baldwin's narrow and perhaps momentary escape from state-imposed death, despite inadequate counsel and reasonable doubt of his guilt, is a stark reminder that execution is final. And if the state has made a mistake in carrying it out, the mistake cannot be corrected or redeemed. So, let me know what y'all think, y'all. Are y'all for Tim being executed? Do y'all feel that there was enough evidence? Was it all just circumstantial evidence? Basically, do you feel that they had factual evidence on behalf? It was all hearsay. And hearsay, whether it's Mary's hearsay, Tim's hearsay, Paul, or anybody else's hearsay, all they actually had was hearsay. Now, the fact that they did find a safe with Mary James Peters, safe deposit checks and stuff, and the fact that there was evidence of Tim's handprints and everything in the home of Mary James Peters, but he was a handyman, y'all. So I really don't know which way to go in this case, but the fact that his daughter testified against him, saying he was facing Old Smoky before the crime was actually committed, and then whenever she asked him a few days later what he meant by that, he meant the electric chair, like, adequately, that would prove that it was premeditated. Obviously, it was intent that he knew what he was going to do. So facing Old Smoky was rightfully so. He was actually faced with Old Smoky, like he said. So I am very curious to know what y'all would think. Shoot us a message, whether, no matter where you're at, any of your podcast apps. Hit us out on email at criminalbehaviorpodcast@gmail.com. You can also submit a form on our website. I'm going to link it in the show notes. It's long, but one day I'll remember that, y'all. Don't judge me. I will leave our links in the show notes as well. There's a link tree, of course, the website, obviously. And basically, like, I just want to know where y'all stand at on this case or any other cases that I covered. If you want to be a guest on the pod, obviously reach out. I would love to have you. And again, tomorrow is August 1st, 2024. The Women Podcasting Awards start, so please vote for me if you would so kindly do so. Under documentary true crime podcast. Again, it's going to be a link directly in the show notes, so please vote. Voting goes on until October 1st, 2024, and winners of each category will be announced on October 22nd. So if y'all were wondering about that, the winners will be announced on October 22nd. There are 3 in my category, which is documentary, but either way, I'm just grateful for being a nominee. So I want to thank y'all for listening to us. Again, please rate, review, share on any of your social medias, on any of our websites and social medias. Just get the word out. I mean, even if y'all don't even want to vote, I mean, again, I said this before, I am not in it to be famous. I'm in it to get these stories out. I am trying to educate the public on what's happening. Some people are very, what's a good word to say? Clueless. I think that's a nice word. Some people are very clueless as to thinking that a lot of this is just happening away from them, but yet it's actually happening in the backyard, in your front yard for that matter. Hell, it happened in my life, in my family, or like affected my children. So like, hello, open your freaking eyes. It's literally right in front of you. It could be someone that you know forever and wouldn't think that they would do things like such, but turns out that they actually do. So you just never really know who you're living with, who you're talking to. So y'all just watch for them signs, y'all. But if you enjoyed our show, please rate and review us on any of your podcast apps: Apple, Spotify, YouTube, Amazon, Wondery, Spreaker, wherever. And be sure to come back on Friday. I will be releasing another episode, and tell your friends about us, y'all. Vote. And until then, this is your host, Sarah Strier, and I hope you have a wonderful night. And remember, sometimes the people closest to you are the ones you should fear the most. I'm out, y'all. Hope y'all have a great day. I'll see y'all on Friday. Thank y'all. Bye-bye.